Okay, welcome everyone. Appreciate your attending today. And just a reminder that you should not be video or audio taping or taking pictures of this oral argument. Also a reminder that if you are citing to the record, we appreciate a record cite. And of course, rebuttal is for rebuttal only. And please keep track of the time because we've got some extra attorneys in here. So just make sure you're focusing on the clock when you need to. Okay, so with that, we will call case number 20-20339, DC versus Klein. And we will begin with Mr. Brush.
Good morning, and may it please the court. My name is Jonathan Brush, and I represent the appellant, the Klein Independent School District. In my time before the court this morning, I will demonstrate that the district court and the hearing officer reversibly erred in finding that the district violated its child find duty under the Individuals with Disabilities Education Act, the IDEA, finding that the individualized educational plan prepared for the student was inappropriate, and by awarding compensatory relief without conducting an individualized evaluation or determination of the student's needs. Turning to the question of child find. The district court improperly concluded that the trigger date for the district's child find duty was April the 27th, 2017. In actuality, the district's duty was not triggered until the beginning of the following school year, September of 2017. The district court primarily relied upon the fact that the student had a disability. That's an undisputed fact. The student had a disability and had been receiving Section 504 accommodations. But by focusing upon the student's disability alone, without focusing on the second prong of this court's test that requires both the existence of a qualifying disability and a need for special education services, the district court improperly collapsed the analysis. Now, with respect to the need for special education services, that did not become apparent to the school district until the summertime of 2017. In fact, the student was expected to pass all of his classes in fourth grade. He did pass his classes, and he was expected to pass the STAR examination. Surprisingly, he did not pass the STAR examination after fourth grade, but that's information that was not known to the school until the summertime. With those facts in mind, the district court clearly erred when it determined that the district had a suspicion of the need for special education services before the beginning of the school year, the new school year, fifth grade school year. Looking at the fifth grade school year, once that year started, the district took proactive steps consistent with this court's precedent to fulfill its obligations under child find. Upon receiving a request for an evaluation from the parents, district representatives met with the parents and they began gathering data to assess the need for an evaluation. And by October 16th, they had consent to evaluate. This court's precedent requires proactive steps to satisfy the child find obligation. The steps the district took in September of 2017 are precisely the sorts of steps that this court endorsed in Woody versus Dallas ISD.
You know, we have limited time, so I want to jump to an issue that I want to gain a little more understanding of, which is the issue of mootness on the compensatory relief. I realize you don't think it matters whether it's moot because of the attorney's fees issue, but let's assume arguendo that it does matter. So I want to ask about it. It seems like both sides should know whether DC actually got the 108 hours or not. And it seems like you all said to the district judge that it was happening. And it seems like DC's family is ceding that and saying it did happen. They did get the 108 hours. So why are we deciding the 108 hours? We can't undo, you can undo money, but you can't undo hours as far as I know. So how can we undo the 108 hours if those were wrongly granted?
Yes, Your Honor, the court quite clearly cannot disgorge the hours or issue an order to disgorge the hours. The record does reflect that the district began complying with the hearing officer's order as it was required to do so. Now, the court still will need to decide that issue if the court reaches the issue of compensatory services, because if the court does not reach that issue, and it does go to the attorney's fees issue, if nothing else, unless the court determines whether the award was appropriate or not, then DC would remain a prevailing party. Because by receiving the award of services, he received a change in position vis-a-vis the school district.
But what about if we affirm on the IEP finding, then doesn't that make DC the prevailing party anyway, even if the 108 hours is in question?
No, Your Honor, because even if the IEP had deficiencies, if he continued to make progress, it might have been a harmless, but well, with the IEP, you would have a substantive violation. But the question still becomes, what was the remedy necessary? Did he need a remedy? And sometimes a student may need very little remedy.
Well, I mean, he got one though. So again, I understand you're challenging that. I respect that. But again, for purposes of this discussion, let's assume you lose on that point. Then why doesn't that end the attorney's fees issue, at least the prevailing party side of it? You haven't challenged the amount. And where we don't have to reach the 108 hours, because it doesn't seem like you're disputing that y'all have done the 108 hours, and DC's family is not disputing. In fact, they've conceded that it's moot. And therefore, I'm just wondering why we have to decide what is otherwise a very complex issue, and where we have amici to help us, but why are we deciding that issue?
The court would still have to decide it because it's still the question of remedy. And the court would have to decide the remedy question tied to the question of violation. And so separate and apart from the attorney's fees issue, if DC was not entitled to a remedy, then the court should address that issue. But regardless, with the attorney's fees issue in the case, it's not moot.
Okay, I've heard what you've said. Go ahead.
Very good. I'll return to the child find analysis quite briefly, and then turn to the question of the IEP. With respect to the child find analysis, the district took proactive steps as required by this court's precedent during September. The only way a violation of child find can be affirmed is by counting the summer months. And the summer months simply do not and should not count. In fact, Texas's regulations make plain that school days are the determining factor for purposes of setting the timelines. Now, Pelley has no answer to that. In Pelley's brief, they did not address the question of the Texas regulations, merely citing instead the federal regulations that impose a 60-day timeline, but those federal regulations do not apply when the state sets its own timelines. Here, the district was entitled to the school days timeline, which means the summer months should not count. When the summer months are removed under either the September or April triggering date, the district complied with its child find obligation.
Would you remind me how school days are defined in Texas? Does it include summer school or not?
It does not. It is, well, it's school days for the school district. Summer days are only implicated if extended school year is recommended or necessary for the special education student, which was not the case here. So the school days.
I'm just trying to understand sort of the core of your argument, which is, well, the summer, man, we're just all, sleeping on the beach. Whereas I know that schools have summer school. A lot of the staff is there working. I realize teachers may not be. I realize that it is a different time of life, if you will, in the summer. But the notion that the school is entirely shut down is not entirely accurate. So that's why I'm trying to understand that, the core of your argument.
It's general school instruction days. It's days when the school is open for providing instruction to the general population of the school district is the denominator under. Okay,
so nowadays summer school can only be for people who have problems. You can't attend if you're a regular student and you just enjoy it. Because I went to summer school for fun.
I don't know the answer to that question, Your Honor. But for purposes of the calculation, if you went of your own volition, you wouldn't be part of the general population going to school during the days of school instruction.
It was an interesting summer, I'll say that. Okay, so you're saying it has to be, I don't know. So you're saying that summer days will never count even if there's summer school?
That is correct, Your Honor, with the limited exception of where extended school year services are required for the student at issue. I'd like to shift to address the substantive appropriateness of the IEP. This court well knows there's a 4-factor test that assesses the IEP sufficiency. Factors 2 and 3 favor the school district. Those are the least restricted environment and the coordinated and collaborative environment. With respect to the first factor, an individualized plan, the district court clearly erred in determining that the plan was not appropriately individualized. The district court focused on the fact that it could not determine how many of the reading co-teach hours were dedicated to the student here. To the extent the district court couldn't make that determination, that was a failing in the petitioner's obligation to carry the burden of proof. The record evidence, and this is Record on Appeal 4490, shows that the special education services were to be delivered in reading and reading only. Absent contrary evidence, the court has to assume, and the district court was obligated to assume, that all of that instruction was given to the student. The hearing officer, to support his finding, cited two pieces of evidence. One was the record citation I just referenced to the court, 4490, which shows special education in reading. And the second was a transcription of testimony which is found at the record on 7176, 7177. And the testimony in that section does not stand for the proposition that the co-teach services were shared or administered in any other setting other than reading.
Counsel, what was the purpose of providing the 3.7 hours per week of the co-teach reading services? What was the purpose of that?
The purpose was to help the student attain appropriate progress in reading. It was to teach him on his reading goals and to meet the reading needs that he had. It was specifically targeted towards reading.
But reading or reading comprehension, because, I can read a lot of things in foreign languages out loud. That doesn't mean I'm comprehending it.
Correct, Your Honor. That's a very fair distinction. It's going to the specific goals in his IEP that were focused on reading comprehension was one of the goals. And so they're focused to his specific needs and not general reading.
So the intended result would have been an improvement in score and comprehension, reading comprehension?
That would have been an intended result. And in fact, going to the fourth factor, that was the result. And we lay this out on page 35 of our brief. Not only did DC pass all of his classes, including reading in fifth grade after the IEP was put in place, he passed the STAR. Those two factors alone compel the conclusion that he made appropriate progress under this court's precedent in Hovum and the Supreme Court's precedent in Rowley. But additionally—
And you attribute that to the IEP?
Yes, Your Honor. It's attributed to the IEP and to the services, and there's no evidence that would suggest that it came from any other source. While the district court—
So we shouldn't offer any contribution to the accommodations provided in the Section 504 plan?
At that point, no, Your Honor, because the court is looking at progress. I see my time has expired. May I conclude answering the question?
Go ahead.
At that point, we're looking towards the progress after the implementation of the IEP in March of 2018, and we look at his progress at that time. So it's an interesting question, though. If we attribute it to the 504 plan, then that would undercut a finding of a child find violation. But it's focused on the IEP, and I would direct the court to page 35 of our brief.
Okay, thank you. We respect that you deferred some of your time to one of the amici, so we will next hear from Ms. Bowen. You need to unmute.
Apologize, Your Honor.
No problem. Go ahead.
May it please the court. Appropriate, addressing the unique needs of the child, and most importantly, individualized. These are the hallmarks of the IDA, and any relief ordered for a violation of the act should be designed to ensure that these hallmarks are achieved. On behalf of 800 public school districts in the state of Texas, Tasby Laff asked this court to establish in this case that a qualitative, individualized approach, as opposed to the hour-for-hour, rigid, quantitative approach, is the appropriate standard for determining a compensatory education award for three important reasons. First, the qualitative approach accomplishes the purpose of the IDA to provide individualized services based on the student's unique needs. Second, the qualitative approach is generally accepted in other circuits and by the Texas Education Agency. And third, the qualitative approach will provide much needed clarity and guidance, particularly in light of the COVID-19 pandemic. First, the qualitative approach—
on whether it's moot.
Yes, Your Honor, I do not believe that this question is moot. It is, if you look at the cases that discuss mootness in the compensatory education arena, if compensatory education is still available or is still possible, it is not moot. In this case, when we're talking about the qualitative approach, we look at the individualized needs of the child. And so the court could offer even more services than the services that have already essentially been completed by Klein ISD. So if looking at the qualitative approach, you focus, as indicated in Andrew F. versus the county, the Supreme Court in Andrew F. versus Douglas County, you focus on the particular child. That's the core of the IDA. So the qualitative approach allows for this individualized focus, and it requires courts to review each child's actual skills and present levels of performance and address the unique needs at the time. With the benefit of hindsight, using the qualitative approach, a court can use the data of the student's actual progress to fashion an appropriate award to best correct the deficit. In contrast, the quantitative approach contradicts the broad discretion afforded by the IDA and handcuffs courts, hearing officers, and the school district from determining what is appropriate for the child. The quantitative approach may also interfere with the district's ability to educate students in the least restrictive environment by requiring a student to spend more time than necessary receiving comp services away from their non-disabled peers. In contrast, the qualitative approach focuses on the quality of the services and the actual harm to the student and allows—
Ms. Bowen, are you asking us to go all in on a qualitative and prohibit any consideration of quantitative?
The qualitative approach includes a review of the actual numbers of hours, of course. But what I am saying is it's abuse of discretion to stop there and not look at the individualized needs of the child and the harm to the child, and focus on the IDA's purpose of providing appropriate and individualized services to the student. So it's not—
You agree that the IDA envisions that the goal is to sort of maximize remedial flexibility. You agree with that?
Yes, Your Honor, I do.
The amici on the other side say that we would unduly constrain discretion if we took the quantitative method off the table.
And Your Honor, I'm not saying that you take the quantitative off the table. I'm saying it is included in the qualitative analysis, but the focus then focuses on the child instead of just a rigid hour for hour a measurement of what is going on. The quantitative approach is abuse of discretion if it stops there without looking at the current needs of the child and individualizing the award so that the main purpose of the IDA is accomplished. This focus has been accepted by the DC Circuit, the 6th Circuit, the 9th Circuit, and the 11th Circuit. And in addition, the Texas Education Agency has specifically instructed Texas school districts to apply this qualitative approach during the COVID-19 school closures. This is especially important given the magnitude of COVID-19 pandemic and the U.S. Department of Education's direct—
But this is not a COVID case.
You're correct, Your Honor. It is not a COVID case, but the impact of this decision will affect every student based on the U.S. Department of Education's directive that comp services be provided for everyone. And if I could just complete my conclusion, I see that my time is ended. On behalf of 800 school districts, we ask you to endorse what many courts and the Texas Education Agency have already done and specifically adopt the qualitative approach in the 5th Circuit to provide individualized awards focused on the student's current needs and unique needs. Thank you.
Thank you. So now we will turn to the appellee, Ms. Kerr.
Good morning, Your Honors. I'm glad to be here on behalf of DC and his parents. This court should affirm the district court. The district court did not commit clear error. The hearing officer and the district court followed this court's precedent in all facets of the decision. They followed the district court followed the Krawitz and the OW opinion in terms of child fine. The district court followed Michael F. and the district court and the hearing officer correctly determined the appropriate compensatory education, and most significantly, the change to the child's IEP. So I'd like to address 3 items, particularly in light of my colleagues' comments. With respect to child find, the district misses the point. Child find is not waiting until the parent asks for an evaluation. Child find is proactive, and that affirmative duty has been recognized by this court repeatedly. In this case, the district court said, under the circumstances, child find was violated. What were those circumstances? Well, the child had been in RTI for almost 4 years, something that this court said should not be a substitute for special education. The child had failed the fall benchmarks in 2016, which is at ROA 4531. The child had produced a 2% score on a reading measure known as the MAP, again, 4531. The hearing officer recognized, and the record reflects that as of March 9, 2017, when the school district was annually reviewing the child's 504 plan, which is at 4522 to 4524, the child had to have all the reading done for him, reading assignments, reading directions, reading answers, reading tests, and even having all of those options on the star. The child, in other words, was stalled in his reading comprehension. Those are the facts. The special education administrator for this district, Ms. McFarland, admitted the child made no progress in 4th grade, and he should have been referred in mid-4th grade. ROA of 274 and the audio of the tape from 2018. So in this context, passing classes, as the district court recognized, was not really an indicator as it might be in other situations. What the hearing officer did here was correct, and the court affirmed it. The consent, the hearing officer said, should have been by April 27th. He chose that date constrained, he thought, and without the Spring Branch versus OW opinion that would have allowed him to go back to March. He chose that date because of the statute of limitations. He looked, however, at the evidence both prior to and after that date, which is allowed by the OW decision. And he said, look, they should have known by April 27th, given that he was stalled in 4th grade. He called the child's progress plateauing. And he said they should have gotten the consent out in 15 days. That would have been May 18th. The evaluation would have been done by October. The ARD would have been done by November. That is at ROA 4158. So recognizing what the district did here, this whole argument about summer doesn't really apply. The hearing officer carefully acknowledged the Texas law, calculated his numbers, ignoring summer. But as the district court said, therefore, the whole summer argument is a red herring. This district knew this child had been struggling for years. The parent had asked as early as 2015 for an evaluation. The district said, we'll keep an eye on him, we'll monitor him, and they didn't. So, in other words, what the parent asked for is one issue at times. But in this—
Does summer count or not?
Pardon me?
Does summer count or not?
We believe that the court doesn't have to decide summer in this particular unique instance. But our view is that the United States Office of Special Education letter to raise, which is cited in our brief, that applies. And that says for an initial evaluation, and this is an important distinction, these children get evaluated all the time. Reevaluations happen frequently. What the United States Department of Education has said, when it's a first evaluation, then you don't let the school district off the hook for the summer. Why? Because it's really important. It's usually the first time they've been evaluated. So the district court took into account, I think, that, look, this child's parent had asked before and the school had refused. And so, no, the summer should not be counted in all cases, but in this case, it can't be counted as an excuse for the district, because the district knew far before summer. The district knew as of March. Had they, at the time of his 504 meeting, which happens all the time, said, gee, maybe we should refer you, they would have been well within the time frame to get that eval done.
What about any delays caused by Hurricane Harvey?
Well, we again think that's sort of a red herring. September 3rd was when the parents' request came in, and September 6th, the schools were back in session. So at most, it was a couple of days, not the months that we're dealing with, Your Honor. We also like to address the fact that there was no clear error by the court in regard to the IEP being insufficient. The hearing officer heard testimony and
if we agree with you on that, does that answer the question of whether you're a prevailing party for purposes of attorney's fees?
Yes, with respect to the mootness question that the court raised earlier, and the completion of the compensatory ad and that question, there is evidence in the record that the compensatory ad has been completed. We don't dispute.
And you conceded that in your brief.
We did. The compensatory ad was provided. The child received it, completed it while the case was pending in this court.
So if we end up concluding that the compensatory question is moot, I'm not saying we will, I'm just saying if we do, then would you still prevail on the attorney's fees on the IEP argument if we agreed with you on that, we affirmed on that?
Yes, I believe that the attorney's fees would have to be decided if the court decided.
Well, they didn't challenge the amount, so I'm just saying, would you be entitled to, would you be a prevailing party? That's my question.
We are a prevailing party, and we believe, and we put this in our brief as well, the district, we believe, had the duty, as this court has recognized in ER versus Spring Branch and in SH versus Plano, the district had the duty to appeal and carefully analyze and brief the fees issue, which it did not do. The primary defense it raises in its reply is that it made an offer of settlement. The offer of settlement is not in front of the district court. It was never put in the briefing. So we believed that they have waived the issue of attorney's fees. They had the opportunity to brief that, to put that offer of settlement in before the district court, and they did not do so. So we believe they have waived the attorney's fees. And
well, I mean, their argument seems to be you have to win on the compensatory remedy in order to be a prevailing party. And I'm asking, even if we determine that to be moot and don't reach the merits, if we all affirmed on the IEP, then are you a prevailing party?
We're absolutely a prevailing party on both aspects of the hearing officer's decision. And if I may elaborate, in terms of the hearing officer's decision, hearing officer very, very carefully looked at the IEP and modified the IEP. And as this court decided in Kraywitz, when a hearing officer makes changes to the IEP, says this IEP needs to be changed in this fashion, which the hearing officer below did and the court affirmed, then that is a prevailing party. And in this case, the child's program was changed, so there would be a focus on reading comprehension, and it would be in a one-to-one or very small group situation. So finally, with respect to the issue of the remedy and the issue of the IEP and the qualitative, quantitative analysis, in this case, the hearing officer very carefully looked at both types of approaches. This court had not yet ruled in OW when the hearing officer had to make his decision. So he looked at both options, and then he did what was very acceptable, well within his discretion. He figured out first, what has the child lost? And he said, reading and comprehension instruction. He figured out how much that was. It was about 108 hours. Then he determined, what do I do to make the child whole? And he didn't just reflexively say, oh, you get 108 hours. He tailored it. He said, I want it in reading comprehension. I want it one-to-one. And so in that respect, he fulfilled the purpose of compensatory education in terms of.
one-to-one when everything else was in a small group?
I believe his intent there was there had been discussion at the hearing by Dr. McKinney, the school's expert, and others about a program called Read 180, which is often provided in sort of a one-to-one or computerized instruction with one-to-one assistance. So the hearing officer listened to the testimony of Dr. McKinney, who said this child needs help in reading comprehension. That's the core of his problem. And both sides had discussed in the testimony one-to-one instruction. I think the intensity is what people had discussed. So basically, when a hearing officer says, I'm going to tailor this, I'm going to give this differently to the child, you're looking at what hadn't worked. And what hadn't worked was the classroom type basis in either the co-teach or in the usual dyslexia program. The school district explains in their opening brief at page 10 that the co-teach program for this child wasn't really 3.7 hours a week. It was about 8 to 10 minutes a day, not the 3.75. So that is how the school district was trying to escape the amount of compensatory education awarded. But in essence, what it did is to show that the district had not prepared and given this child an appropriate level of instruction. Finally, Your Honors, I do want to address Mr. Bush's comment about the least restrictive environment and the other factor of the Michael F. test. The Michael F. test doesn't say you have to, sort of give one factor through the other. There are going to be times when one factor doesn't apply. You don't just assign a factor and if there's no dispute about it, then it becomes someone's win factor. And that's what the district's trying to do with the LRE. There was no burden of proof on the parent at the district court level. It was the school district only that appealed. So with respect to what the child was learning or not learning, we lived with what the hearing officer ordered. The school district appealed. So everything that was a burden belonged to the district at district court, except for the fees, which they didn't fully respond to. Finally, with respect to the bottom line here, the bottom line is not about whether the hearing officer was wrong, the district court was wrong, because there was no clear error. What the district is concerned about, and it comes through both in their brief and in others, is an attempt to sort of scare the court about floodgates in light of COVID. This case was not a COVID case. This case was decided well before COVID happened. And this court can distinguish that. This court can say we're not deciding this in light of COVID. The passing classes that is mentioned repeatedly by the school district, as the district court said, was really not the test. And why is that? Because child was passing classes before he had an IEP and after, because he's a smart child. But the deficit, the distinct deficit he had of reading comprehension was not caught by the district in a sufficient time, and he was not provided the services that he needed to be provided. That is all I have, unless the court has questions.
Okay, thank you. We appreciate your argument, and you ceded some of your time to the other amicus. And so Ms. Saideman, I'm not sure how to pronounce it. There you go. Oh, no.
It's Saideman. May it please the court, my name is Ellen Saideman. I'm here today for the amici, Council of Parents, Attorneys, and Advocates, and Disability Rights Texas. We're here today because compensatory education is an essential remedy for students with disabilities. Most children with disabilities don't have parents who can afford a unilateral placement, so it is important that compensatory education be an effective remedy for them. It's important to realize that with the unilateral placement, the student does get the free appropriate public education the student needs, and the parent is just seeking reimbursement, money. But for students like DC in this case, their parents can't afford or don't have access to FAPE. And instead, the student is waiting until the court reaches its decision, until the student is able to get the free appropriate public education that they need.
Could you clarify? I wasn't sure I completely understood in your brief. Are you arguing that quantitative is the appropriate measure, or simply that quantitative is an optional measure, or just that qualitative can encompass quantitative? And so what is your world? If you were writing our opinion on this issue, what would you be writing?
If I was writing your opinion, I would say that the district court, in its discretion, the hearing officer and the district court, in their discretion, can evaluate the request, the relief, and determine what is appropriate in a particular case, which may be the quantitative approach or may be the qualitative approach, depending on the individual facts of the case. And that's
They're both available.
They're both available. And the district court's decision, the hearing officer's decision in this case, makes that clear. The hearing officer considered whether the qualitative award was appropriate in this particular case. And what he said was, in reviewing my decision, I'm determining what's going to make this particular student whole. And what's going to make this particular student whole is the quantitative award, the 108 hours of reading instruction. I think it's important to note that had the student been placed in a unilateral placement for a school that provided education in learning disabilities and reading instruction, the parent would have been reimbursed for the entire tuition for the full day. What the student got in this relief is actually very modest. That many of the cases that have involved qualitative versus quantitative involved enormous awards, such as the Draper case, where the 11th Circuit upheld an award of 5 years of private school. Here, the award here was 108 hours of instruction by a school department employee. And I think it's important, Judge Haynes asked about the one-on-one instruction. I think it's important to note that because compensatory education is usually delivered beyond the traditional school day, because it's in addition to the education the student would normally get, it's often provided after school, before school, or during the summer. And because you may not have a group of students who are similarly situated who've also need education at that time, it's often delivered on a one-on-one basis. So that is not unusual. One thing I do want to note, it is concerning that it does appear that the school district's main reason for this appeal is to eliminate the parents' claim for attorney's fees. I think it's important to note that this court has held in the Lauren C. case that the question of mootness does not preclude the award of attorney's fees. Under Buchanan, the parents obtained an award, both in the hearing and at the district court, of compensatory education. If the case becomes moot by the district's action in complying with that order, it does not change the fact that the parents are the prevailing party and entitled to fees for the compensatory award.
Well, but they're saying they shouldn't have been the prevailing party, that we should decide that question on the compensatory.
But since the student has gotten the compensatory award, it's moot.
Okay, but they're saying we should decide whether that was right in order to decide the prevailing party to decide the attorney's fees, as I understand the argument they're making.
Right, I get that. But as a lawyer who's represented many parents, many times my clients would like to continue litigating cases until they got an order that they won because they want to get paid for attorney's fees. But that's not the way the law works. Once the issue on the merits has been resolved, the attorney's fees is an ancillary claim, and you can't continue litigating just so that you get a victory that defeats or allows you to get attorney's fees, because that would mean that this litigation would continue forever. I think the case law is pretty clear that you can't continue litigating just because you want to change the prevailing party status.
Okay, your time has expired. appreciate your argument, and we will now turn to rebuttal with Mr. Brush.
And please the court. With respect to the mootness discussion we've been having, if nothing else, this case is not moot and the compensatory education question is not moot because this would be a case that is capable of repetition yet evading review, which is a well-recognized exception to mootness and in the Honing case from the United States Supreme Court, which is an IDEA case. The upshot of the mootness argument that appellees and their amici have made is that if it is a small award of compensatory services, it will always evade review because of the length of the litigation process. The capable of repetition yet evading review doctrine.
Are you not able to get compensatory education stayed?
No, the school district is required to comply with the hearing officer's order.
Immediately? Okay.
It would force the hand in every case where a smaller award of compensatory services is made. The case would become moot during the litigation process. And the Supreme Court has long recognized that as an exception to mootness. No part of this case is moot. I'd like to address my colleague's comments about page 10 of our briefing. It's abundantly clear from the brief that what the district is describing is the offer of compensatory services that was made during the ARD committee meeting as a way to placate the parents because they had been upset at the prior meeting. The hearing officer expressly found at finding number 64, which is at 4137 in the record, that it was not an admission of guilt and was merely an offer in an effort to be collaborative. That's undisputed. To the extent my colleague is suggesting that the district was actually only providing 8 minutes of instruction a day under the under the special education that was provided, that is plainly a misreading of the briefing and the hearing officer's unappealed finding. The evidence in the record is clear that the district committed to providing 3.75 hours a week. It was targeted towards DC's need, and there is absolutely no evidence in the record to suggest that he did not receive the benefit of those services. To the extent the hearing officer and the district court held otherwise, they were simply speculating. And as this court knows, speculation is clear error if it's all that underpins a judgment. And that's all that underpins the finding on prong 1 under the Michael F. factors. Now, opposing counsel suggested that the other factors don't matter. Well, they do. Least restrictive environment is a core component of the IDEA. As this court knows, there are whole cases on least restrictive environment. The fact that the district was able to educate DC in the least restrictive environment goes to the fact that the program was individualized to his needs. The district had him in the right place. Finally, I think it's telling that when my colleague was asked, do the summer months count? She wouldn't quite admit, but essentially admitted that they don't count, but maybe should here. That's not an appropriate rule of law. The court should hold that they do not count. We respectfully request that the court reverse and render.
Okay. All right. Thank you very much, counsel. We appreciate all the arguments. We appreciate the amici and everyone's arguments. And the case is now under submission, and we will excuse you from this virtual courtroom.